Things, global happenings today. We communicate, we analyze global news. Stay tuned.
Hello, beautiful people. Welcome back to Global Happenings Today YouTube channel. Some few hours ago, literally, Peter Obi Labour Party legal team have actually petitioned or written to the justices, the Supreme Court, over the omitted verdict, that they joined issues with PDP with them, but they didn't give them their own verdict because the evidences they brought were far different from what PDP tendered. But apparently the truth is coming out, and this is getting really messy. The question is, how did we get this low? I just hope eventually somebody will be penalized over this whole drama that is about to unfold. But before we go into the newspaper to find out what is going on, like and subscribe to our channel by clicking on the right subscribe button. Beside it, you see a bell notification icon. Please go ahead, click on it to get notified as soon as you update our channel on YouTube. Now, a human rights activist named Akume has petitioned the Chief Justice of Nigeria, Chairman National Judicial Council, that's NJC, Justice Olukayode Ariwola, to probe the 6 judicial officers for what he described as gross misconduct. Now, the petition, which was received and acknowledged by the Office of the Chief Justice of Nigeria on November 29th, 2023, was brought pursuant to the Code of Conduct for Judicial Officers of Federal Republic of Nigeria 2016, Section 2, under application of the Code. Now, it is titled Petition or Complaint on Misconduct and or Misbehavior against M.E. Anania J.A. Itonyaman, J.A.O. Adenije, and Biobale Abraham, George Will J.C. Folashade Ayodeji Ojo, J.C. Peter Chude Obiora, J.C.A., the petitioner Akume. Now, it decried the perverse judgment in the matter of Kula M. Satumai and PDP versus INEC, APC and Senator Mohammed Ali Ndume with election petition number EPT/BOR/Sanders SEN/02/2013, delivered on 8 September 2023, and appeal number CA/G/FOSLAG/EP/SEN/BR/04/2023, delivered on 2nd of November 2023 at the Court of Appeal sitting in Abuja, respectively. Now, Akume, while calling on NJC to investigate the circumstances around the complaint and bring the offending judicial officers to book, said it was preposterous that aides and supporters of Senator Mohammed Ali Ndume, a respondent in the tribunal, had details of the tribunal judgment and gleefully shared the outcome of the judgment on the morning of September 8, 2023, before the tribunal read the judgment in the afternoon. Citing lots of perversion in both judgment of the Election Petition Tribunal and the Court of Appeal, Akume reminded NJC chairman of the report on pilot survey published by the Independent Corrupt Practices and Other Related Offences Commission, ICPC, where the judiciary tops in bribes demanded, offered and paid. Now, petition partly reads, and I quote, "The complaint is made against M.E. Anania J, A.I. Itonyaman J, and A.O. Adenije J for their perverse judgment in the matter of Kula M. Satumai and PDP versus INEC, APC and Senator Mohammed Ali Ndume with election petition number EPT/BOR/SEN/02/2013, delivered on 8th of September 2023. Now, in the said election petition tribunal judgment, the judges arrived at many conclusions that the Court of Appeal found to be perverse and repeatedly stated so on the record. The tribunal held that further evidence provided in response to a counter filed by the opposing side was inadmissible for being filed out of time, as it ought to have been filed from the onset. It held that any testimony given by an individual perusing document tendered was mere heresy, as long as the individual was not physically present when the documents were produced. These are two of numerous ludicrous holdings by the tribunal to arrive at what appears to be a predetermined judgment, working from the answer to the question just in order to return the third respondent as the duly elected senator for Borno South. It is worth noting that aides and supporters of Senator Mohammed Ali Ndume had details of the tribunal judgment and gleefully shared the outcome of the judgment on the morning of the 8th of September before the tribunal read the judgment in the afternoon. It then begs the question, how did the supporters get details of the outcome of a judgment that was yet to be delivered? The Court of Appeal in its perverse judgment dismissed most of the findings of the tribunal, but in the end still upheld the judgment. The Court of Appeal, for instance, held that the appellant did not prove a case of forgery, mutilation, or defacing of result sheet, having seen the forged, mutilated, defaced result sheet, or how the hundreds of forged, mutilated, defaced result sheet affected the outcome of the election. The court held to stringent and impossible requirement to prove the same, even though forgery has repeatedly been defined to include authoring an original document. See Nigerian Efforts vs. James 2002, 18 NWLR, Part 798, Sub 295, and numerous such authorities. Now, he noted that the Court of Appeal at page 42 of the judgment, part Judgement JCA, considered that I found the evaluation by the lower tribunal of the evidence of PW1 to PW47, the witnesses called by the appellant, the evidence of RW1, and the totality of the evidence laid before it by the parties was flawless, and the findings was flawless, and the findings and decisions on the merit of the claims of the appellant against the respondent are unassailable and must therefore be allowed to stand. And yet, the same court upheld the judgment of the tribunal. It is judicial abracadabra, as this which makes no meaning to the average reasonable person, that continues to bring the judiciary to disrepute and erode whatever confidence the public might have had in the independence, integrity, impartiality, and respectability of the judiciary in Nigeria. The NJC would do well to investigate the circumstances around this compliance and bring the offending judicial officers to book in order to begin redeeming the standing and image of the judiciary, the petition reads. Now, everybody is collecting water. We are moving somewhere. When they did it with Obi, it was okay. After all, some people are shouting, we will stand on that mandate. Now, that particular blueprint is now what they're applying to all others. Now, according to the petitioners, they said even Senator Ali Ndume is also a beneficiary to this judicial abracadabra, quote and unquote. I'm not the one that said it. The petitioners are saying it. Now, a case of forgery, which has already been constitutionally written and defined what forgery could connote in our constitution, is now said that it is not so and it is not true. And now, if we continue in this fashion, will there truly be an election? Let them select, go to the judiciary, do their selection, and move on. Nigerians are gradually losing faith in what they ought to have put hope on. Let's meet in our comment section. What's your take?